20 साल केस चला वो।
Wow,
हाँ,
it's crazy. Litigation हमारी country में कितनी देर
बहुत
elongate हो
राणा
जाती है.
साहब,
यस
अब हम लाइव हैं,
ओके
अलाउ करें तो मैं स्टार्ट करूं?
यस प्लीज स्टार्ट यस
प्लीज।
हाय हेलो
सर
हेलो
गुप्ता
राणा।
सर, अगर आप प्लीज म्यूट कर लें आप अपने आप को। या
हेलो
म्यूट कर लें सर। ओके, गुड इवनिंग respected President Mr. J.S. Rana ji, Secretary Mr. K.G. Bansal, Joint Secretary Mr. Mithilesh Tiwari ji, Joint Secretary Mr. G.S. Pathak ji, and our Treasurer Mr. Tiwari ji, and today's our speaker Ms. Kanika Agnotri, senior members of this bar, and our professional colleagues, and today's our coordinator Mr. J.C. Gupta ji. I, on behalf of Delhi Tax Bar Association, welcome you in 14th webinar. Friends, as you are aware that today's our topic different from tax law. Personally, I feel that being a lawyer, we should be aware about the recent legislative development. On such major development in recent time was related to Consumer Protection Amendment Act. Many of you will be aware of that. Consumer Protection Act 1986 now stands repealed. In its place, a new act has been brought, which has many circular changes like the provision of jurisdiction, cause of action, filing of complaint, etc. But what is for us to see is that whether these are mere cosmetic changes or will be having some substantial impact in the functioning of consumer protection. To throw light on this subject, we have with us Ms. Kanika Agnotri. She has a very rich experience and expertise in the matter of consumer protection. Without wasting much time, may I request our President, Mr. J.S. Rana ji, to give his opening remarks and brief introduction of our speaker, Ms. Kanika ji. Over to Rana ji, please. Rana ji, unmute कर लें, please.
थैंक यू रामानंद जी। Respected Sri Rajesh Mahana ji, Senior Member and Ex-President of DTBA. Respected Sri V.K. Vashne ji, Chief Patron and Ex-President of DTBA. Kanika Agnotri ji, today's Speaker. Sri Ramanand Roy, Convener and Vice President of DTBA. Sri K.G. Bansal, Secretary DTBA. G.S. Pathak, Joint Secretary DTBA. And Mithilesh Tiwari, Treasurer DTBA. And Sri J.C. Gupta ji, coordinator of today's virtual meeting, and other senior members and friends. I, on behalf of Delhi Tax Bar Association, welcome you all in this 14th virtual study circle of Delhi Tax Bar Association. Dear sir, before going further, I tell about our bar as we are discussing. Our bar is oldest and largest bar of tax lawyers, more than 800 members. And this is our 14th virtual study circle meeting, which is record in comparison to other bars. Now, I give brief about our today's speaker, Kanika Agnotri ji. Today, our topic is Consumer Protection Act 2019 amended. Kanika Agnotri ji did her LLB from Punjab University and enrolled as an advocate with the Bar Council of Delhi in the year 2002. After that, she started practicing as an independent counsel before the Honorable Supreme Court of India and Delhi High Court, as well as before various tribunals, including National Commission, State Commission, etc. Agnotri ji has also worked on the matter of national importance as an associate in the office of Karan Jwala and Company for a period of 2 years. And her firm SKV Associates is a well-known and reputed premium law office. She has also been invited to speak on wide topics of law of both national and international level. She is dedicated hard worker in the field of law. You glad to know she is the daughter of Justice Swatantra Kumar Ji, former Judge Supreme Court of India. Ma'am, I welcome you on this virtual study circle meeting and please invite you to give your presentation on this today topic. Kanika ji.
Thank you, sir. It is indeed a great pleasure to be with all of you today to discuss what is a substantive amendment to the Consumer Protection Act, which is now known as the Consumer Protection Act amended 2019. Before I start to share my views with all of you, there is a query that Mr. Roy started with, a thought that he had in his mind, which basically he posed a question as to whether the changes that have been introduced by this Amendment Act are really cosmetic or they're substantive. I hope that after I share my views with you in this matter, that you would agree with me that the amendment is indeed substantive to its very core. It has changed the act, the consumer jurisprudence as we know it. How it pans out, how it is implemented is something that I think time will tell. How it is implemented, how the courts take to it, how the consumers use it for their own benefit, how we lawyers are able to adapt to it is something that time will tell. But the answer to your question, Mr. Roy, at least in my opinion, is that the changes are substantive. Before we reach the topic of the Amendment Act of 2019, I propose to first discuss the Consumer Protection Act as to why it was first introduced, what the salient features of the 1986 Act were. Before the amendment that we are dealing with today, there was another amendment which was very substantial, and that amendment was the amendment of 2002. The act that we know, the law that we act is trees of jurisprudence that we are constricted by today as lawyers, at least before the Amendment Act of 2019, was introduced by the amendment of 2002. So I also propose to touch upon that briefly before going on to the Consumer Protection Amendment Act of 2019, in which I wish to discuss with you the need for amendment as to why it was felt by the legislature that this act, which was to a normal, regular eye functioning, operating with smoothness, needed amendment. What the salient of the are a companion act, the old act, and a segregated discussion with regard to the features of the new act, the ones that we feel are welcome introductions, and the ones we feel may cause some difficulty in implementation or which present some ambiguity and may be difficult to comprehend and then implement for us as a legal community and for the society as large. Without further ado, I would like to now discuss why the Protection Act, the very first one in 1986, came to be in place. Linguistically, the term consumerism first came into the Indian vocabulary somewhere late in the 1960s. It is during this time that what was earlier restricted and controlled turned into mass production. After mass production, it gave way to overproduction. Eventually, production ran the supply. There were far more goods in the market, far many more services than were actually required. What this did was it skewered the concept of consumer sovereignty as we know it. Because there were so many products, there were so many services, it enabled the fortified community of manufacturers, of service providers, to manipulate and maneuver the market trends, the consumer psychology in a manner that they were able to take away the attention of the consumer from deficiency in service, from shortcomings in quantity, in quality of service and of goods both. If we see the notes of parliament, the parliamentary discussions, we feel that it is for this to obviate this gutting, adulteration and substandard provision of services and goods that the original Consumer Protection Act of 1986 was brought into place. This act was placed before the Lok Sabha on 5th of December 86 and eventually received the assent of the president on the 24th of December 1986. Before this act, there were several other acts that could be construed to mean to have jurisdiction on the subject matter of consumer protection. An individual could invoke the CPC, Motor Vehicles Act, the MRTP, to address the grievances that he felt he may have against somebody who had given him a product or provided a service. The Consumer Protection Act was supposed to be introduced as a panacea for a consumer to make sure that he has a one-stop shop to address any grievance that he may have against a product or a service. The only exception there was to this was a product or service which had been purchased or availed without paying any money, that is, which was free. If it was not free, if the consumer had paid monies to receive this, the consumer was within his rights to invoke the jurisdiction of the Consumer Protection Act and ask for relief. Very briefly, I would like to share with you what the salient features of the 1986, the original act were. This act put in place the concept of a consumer as was understood by law then, and then what formulated to be a consumer over the legal jurisprudence and how it evolved. It was supposed to be introduced and was in fact introduced as an umbrella benevolent legislation. This was a legislation which curtailed to the private, which sort of was available to the private sector, to the public sector, to an individual, to a cooperative sector, to anybody who had purchased for consideration any good or services. The reason it was called benevolent is something that has become evident over the tenure of this act, where it was implemented in all possible ways to ensure that the consumer got the benefit of the legislation. The original act aimed to provide 6 rights to the consumer. The 6 rights were right to safety, right to be informed, to choose, right to be heard, right to seek redressal, and right to consumer education. This was the act that introduced a 3-tier system to establish for consumer jurisprudence. It started at the head with the National Commission, moved down to the State Commission, and culminated in the toe with the District Forum. The original jurisdictions that were contemplated for these forums was anything above 1 crore would go to the National Commission. I'm so sorry. Anything from 0 to 5 lakhs would go to the District Forum. From 5 to 20 would go to the State Commission. Over 20 would go to the National Commission. This was the original act, largely speaking, that was introduced in 1986. After the 1986 Act, the substantial, and I would say borderline landmark amendment came in 2002. It is this amendment that introduced the act that most of us knew was in operation prior to the Amendment Act of 2019. The Consumer Protection Act Amendment of 2002 came into force on 15th of March 2003. The salient features of this act are somewhat important because they were materially different in terms of jurisdiction from the earlier act. This Amendment Act began with excluding what had only been understood prior to then, which is any person who had availed services or goods for commercial reasons. So there was an exclusion that was introduced within the definition of consumers. If you had bought any product or used any service for a commercial purpose, which is for any purpose apart from your self-use, the self-use of the consumer, then this was ousted from the jurisdiction of the Consumer Protection Act, disabling the consumer from coming to the consumer fora. It also included within the definition of unfair trade practice, the deception of consumers. If any product was seen to have been deceiving the consumer, or any service could have been interpreted as a deception to the consumer, then it was known that that unfair trade practice would be included within the definition of the Act within the ambit of its operations, again, enabling the consumer to come to court. There was also formation of consumer protection councils, which was contemplated with this Act, but I personally feel that that is something that, on account of probably lack of commitment, did not find much force. A material change in this Amendment Act was enhancement of jurisdiction, pecuniary. The district forum could now was now enabled to entertain any complaint where the subject matter in terms of pecuniary jurisdiction went from 0 to about 20 lakhs. The State Commission's pecuniary jurisdiction was enhanced from 20 lakhs to 1 crore. And anything above 1 crore went to the National Commission for Adjudication and for Determination. Under Section 12, individuals, recognized voluntary consumer associations, class of consumers were included in the definition of who can file a complaint. This enlarged the scope very widely, something that came to be interpreted in several judgments by different forums, and eventually came to be settled in the landmark judgment of Amrish Kumar Shukla. It also thereafter introduced Section 13(1)(a), which introduced stricter timelines. Anybody who's appeared for opposite parties in the consumer fora would know that the bane of our existence is ensuring that our written statements are filed within 45 days from the date we receive a copy of the notice and the complaint. It is this Amendment Act that introduced that stricter timeline and ensured that the same was implemented. We all know that the Honorable Supreme Court now has laid down that there is no way that this time limit of 45 days can be extended. So within 45 days, the answer to whatever complaint has been filed against the opposite party must be filed. Section 13(3)(a) of this amendment also introduced a time limit to adjudication of the proceedings. The Act contemplated that from cradle to grave, that is, from the complaint coming to be filed to its final adjudication, the process should take no more than 90 days. That was the stipulation where there was no sample that had to be sent out to get tested. If there was any sample that had to go out to get tested, that case was permitted or actually envisaged to be completed within 5 months. Unfortunately, all of whom we practice in these forums, we know that this is one of those sections which never could really take effect for the simple reason that there is no complaint that has, at least in my experience, been concluded within a period of 3 months, leave alone 5. This Amendment Act also included sections to introduce punitive damages, conditional acceptance, filing of appeals where demand drafts had to be filed before the appeal was filed for the appeal to be entertained. It dealt with constitution of benches, how they will be constituted. And thereafter, interestingly and possibly most pertinently, specific powers were given to these forums. Powers are given to these forums and commissions to pass interim orders and to the National Commission to review its own orders. Now, interestingly, the power to review its own orders was not given to the district forum, was not given to the State Commission. It was given only to the National Commission. If any person was aggrieved by any order passed by the state or the district forum, an appeal had to be filed in the body over that commission to ensure that the grievance can be heard. This amendment also introduced stricter enforcement of orders, giving all the forums power to attach property and be placed at the same level as a judicial magistrate of first class to ensure that all orders passed by them are in fact implemented. This act, it seems, worked its way. It was felt that an amendment to this act was required, which is why the Amendment Act of 2019 was introduced. To discuss with you this topic in 4 heads. First, we will discuss as to why the need for amendment was felt. Then, the salient features of the Amendment Act of 2019, along with differences between the earlier act and that of 2019. With regard to the features of the Act, I wish to segregate them under 2 subheads. One, which we welcome and we feel are very positive introductions into the legal system, and others which, in my opinion, will pose some kind of difficulty when it comes to implementation. Let's begin with why the need was felt to amend the Act and bring in the Amendment Act of 2019. It probably was felt a substantial workload pendency that had been created while in the operation of the earlier Act. Lots of cases, probably thousands of them, are pending adjudication despite every intent of our judicial adjudicatory benches to ensure that they are disposed of. Yet, unfortunately, the pendency has only increased and thus causing a major hurdle in implementation of the Act. One of the material factors in introducing or probably initiating the process of this amendment was the availability or introduction of e-platforms into the global scenario. The Indian economy itself has witnessed a very vast change on account of the introduction of global supply chain, domestic supply chains, rise in international trade, rapid development of e-commerce and e-platforms, giving an entirely new platform for opportunity for concerns for both the sellers, the service providers, and the consumers. This new scenario has also given a very vast opportunity for misleading advertisements, for telemarketing, for misguiding a consumer with regard to a product on account of the fact that it is not being tested or viewed, or the decision is not being made in its physical form. It is being made on the electronic platform. Therefore, the legislature felt a need to bring in an amendment which would include such services, such goods that are being available to consumers, to make sure that whatever the grievance of the consumer was addressed. Now, let's discuss in the background of the differences from the old Act, what the new amendment has brought into place. The new Amendment Act of 2019 principally has enhanced the jurisdiction clause. Now, in this case, it has enhanced the territorial jurisdiction as well as the pecuniary jurisdiction. The territorial jurisdiction has been enhanced in terms of the fact that earlier, the consumer could only file a complaint where either he resided or where the product was purchased, or where the opposite party resided for business. This amendment has now introduced a clause where a complaint can be filed wherever the product has been purchased also. So for instance, I am a resident of Delhi, but I am traveling to Bombay where I purchase a product. It gives me the power to institute proceedings against the OP even in Bombay, even though I myself am a resident of Delhi and the OP himself may be in Calcutta. So how this jurisdiction clause in terms of territorial jurisdiction works out would probably be something that would get clarified over a period of time upon implementation. This Amendment Act has substantially increased the pecuniary jurisdiction of these forums as well. Now, as against the original jurisdiction of 5 lakhs, which was enhanced to 20 lakhs, The jurisdiction of the district forums today stand at rupees 1 crore. Any dispute, any claim, any list between the parties where the value of the goods or services is under 1 crore, that complaint or that list will go before the district forum. Any complaint list where the value of the product or the service availed is between 1 crore and 10 crores, that complaint would go to the state commission. Whereas anything which is over and above 10 crores would go to the National Commission for Adjudication. This amendment has also enhanced and enlarged the definition of consumer. It has included within its definition any person who has engaged in offline or online transactions through electronic media on an e-platform. So anybody who has used any internet service with regard to an electronic platform, whether it's with regard to services or goods, if they have used any site, for instance, you have Flipkart, you have Amazon, you have so many other sites. Any has been used to purchase any product or avail any service from the comfort of your own home. If you are aggrieved with the product, if you're aggrieved with the service, you are within your rights now to invoke the jurisdiction of the Consumer Protection Act to file a complaint against the service provider or against the manufacturer of the product. Section 216 of the new Act has included and defined e-commerce itself. It has defined e-commerce as buying and selling of goods or services, including digital products bought over digital or electronic network. With the inclusion of e-commerce, with the enlargement of scope of the definition of consumer itself, the grounds of filing for a complaint have also been included to enhanced to include the e-platforms and grievances that relate to services or goods that are procured over such platforms. A very interesting introduction of this amendment is the unfair contracts. After we finish this topic, I would like to discuss with you the very conspicuous interplay and overshadowing of jurisdiction which may occur between this new act and other statutes which are already in place. However, for now, let us first discuss what the unfair contracts are as contemplated by the new act. Now, the new act has included unfair contracts in section 2, subsection 6, subsection 1. This act has been introduced to include unfair trade practice where it is felt that the contract was unfair qua one party as opposed to the other. It has now given statutory force to the jurisdiction of the consumer fora to adjudicate on something that they feel or before them is alleged to be an unfair contract. There is something to be said with regard to this insertion. We all know that for quite a while now, all the consumer forums, whether it's the National Commission, State Commission, or the District Forum, have enhanced their jurisdiction and exercised it in manners to come to the rescue of the consumer. The opposite party invariably, actually in most of the real estate matters, would rely on the judgment of the Honorable Supreme Court in Bharti meeting to say that the contract was signed with the consumer with his eyes wide open. He is bound by the terms of the contract. Delay was originally always contemplated. There is a compensation in place, and the parties as well as the court is bound by it. The consumer fora, whether it's the national or right through to the district, have in the recent past enhanced their own powers to rule that contracts, if they are unfair, will be struck down, in as much as in a real estate contract, ordinarily, the opposite party would promise to give ₹5 per month per square feet to the consumer for the period of delay between the promised date of delivery and the actual date of delivery. The consumer forums have invariably said that that amount is insignificant, it is not sufficient, and thereafter have circumvented the rigors of the terms of contract by enhancing the compensation to include vast amounts of money to compensate the consumer for the delay on part of the opposite party. So to a certain extent, the forums have already been exercising this jurisdiction, but now the new amendment, in fact, introduces it statutorily, probably fortifying the position that has already been taken. The concept of unfair trade practice, albeit always was there in the Consumer Protection Act, but now it has interestingly been enlarged to a very wide extent. Now, under the 2019 Act, failure to issue a bill for your purchase is grounds to file a complaint. We all know we have eaten in different joints, like Subway, for instance, or if you go to one of these movie halls, like you go to these multiplexes to watch a movie, invariably at the point of sale, you will find an announcement saying that if you don't receive a bill with your purchase, this purchase would be free for you. Now, that probably had been introduced to ensure accountability, qua the service provider and people employed at his end. But now it receives statutory force. So this would now be a concept which would be available all across the board to everyone. And all entities in business, whether providing services or making goods, will have to make sure that they comply with this. Because if there is no compliance with this statutory mandate, then it could give rise to reason to file a complaint. Another such ground is refusal to accept goods returned within 30 days. Now, we are aware that there are several entities, business entities, places that we buy clothes from, places that we buy electronics from, where if you go back and you take the goods, you show them that the goods have not been tampered with, they have not been sort of harmed in any way, and you can produce a genuine bill along with proof of transaction. These business entities would take the goods back, but a very large section of the business community would not do it. Now there is a statutory mandate that they must. So any product that has been purchased by any consumer, once it's purchased by them and at a subsequent time frame within 30 days from purchase, if it is felt that there is something defective or if there is certain deficiency in that product or in service, you can take it back to the manufacturer, you can take it back to the service provider, and he is bound by statute to take the good back and reimburse you the costs that you have paid towards purchase. There is also now a statutory prohibition for disclosure of personal information of a client, which is available with the service provider or the product manufacturer, unless, of course, it's required to be disclosed by law or in public interest. There is another interesting introduction with the Amendment Act of 2019, which is basically enhancement of the number of members that would constitute the State Commission going on forward. If you would see Section 28(2), 42(3), and 54, you would see that while the constitution of the National Commission, which is president plus 4 members, remains largely the same, the district forum remains largely the same, which is president plus 2 members, the State Commission, which was to be headed by a president plus 2 members, has now been enhanced to 4 members. This is probably a move that has been introduced to bring in the folds of State Commission more manpower, more adjudicatory people to ensure that the flurry of complaints that will now come after the introduction of this act can be entertained and adjudicated upon effectively. We can't shy away from the fact that a very large percentage of the society would, in fact, fall in the bracket of 1 to 10 crores. There are very few people who would fall in the bracket of 10 crores having purchased a product which is over 10 crores or a service which is above 10 crores. So to ensure that the State Commission is equipped to deal with this onslaught of complaints that is probably expected after the introduction of this act, the legislature has already enhanced the capacity of the State Commission, and hopefully appointments will be made soon. This new Amendment Act has also introduced an alternate dispute redressal mechanism. We're quite aware that as a society, the legal fraternity, the legislature is working towards introducing a parallel mechanism, which is called the alternate dispute redressal mechanism. Most of us would know it as mediation, as arbitrations. These are mechanisms that are introduced to try and make an attempt towards keeping litigation outside of actual courts in an attempt to probably bring down the pendency in courts, or at least not to add to what is already pending. The new Amendment Act has now also introduced this parallel mechanism in sections 37, in sections 74 through 81, to put in place an alternate mechanism system to resolve the dispute between the parties. Maybe this will help in reduction of already pending cases. Maybe it will help in reducing the cases that come to be filed within in the courts on behalf of consumers. The penalty clause, which was earlier section 27 of the Act, now finds mention in section 72 of the Act. In this clause, the imprisonment stipulation remains the same. It is a maximum of 1 year, but what was originally contemplated, a minimum of 3,000 rupee penalty to a 10,000 rupee penalty to the maximum, has now been increased, a minimum of rupees 25,000 and a maximum of rupees 1 lakh. So there is an enhancement of penalty in terms of the new Act. What has been introduced for the first time and did not find any mention in the earlier Act was product liability. If you could see sections 82 through sections 87, you will find that there is a product liability clause that has been introduced against manufacturers, against service providers, against sellers. Now, this is not an and clause, this is an or clause. So therefore, it gives the consumer the leeway to go after any entity that he has been aggrieved by. So if a car is purchased, the consumer has the ability today to go after the manufacturer who has manufactured the car, to go after the dealer who has sold the car, to go after the service station which has serviced the car. So this Act has brought into its folds everyone that is involved in the chain of production, from the stage of production to the stage where the service or product is availed by the consumer himself. The new Amendment Act has also contemplated in sections 3 to section 9 central protection councils. Now, these CPCs were also contemplated in the earlier Act. If you will see sections 4 through section 8, the concept was envisioned, but unfortunately, for reasons best known to all the communities involved, has not been implemented with the imprimatur that it was sought to have been introduced in the first go. These CPCs have now been contemplated to be established at the district level, at the state level, and at the national level as well. The most interesting feature, in my opinion, in the introduction of the Amendment Act 2019 is the setting up of a regulator. This regulator is called the Central Consumer Protection Authority, the CCPA. Now, this CCPA is very conspicuous as a first-time introduction in the Act this time. It seems that it is a body as vast as the adjudicatory system which is already in place. This body is supposed to have an investigative wing and have an adjudicatory wing. You would be very surprised to know that while the purpose of this authority is to promote and protect and enforce the rights of the consumers, sections 10 through 27 of the new Amendment Act will make it clear that this authority is empowered to issue safety notices. It has the power to pass orders for recall of goods. It has the power to prevent unfair trade practices, direct reimbursement of purchase prices, impose penalties, impose not just penalties for any, it can impose penalties for false advertisements. It is a very, very powerful body that has been created by this new Act. And interestingly, the commitment of the legislature to ensure that this Act is in fact implemented in all its rigor is evident from the fact that it has been in the news that appointments with regard to the council members of the CCPA have already been made. The government, therefore, is very intent on introducing this authority, which would probably work simultaneously with the adjudicatory legal system as originally contemplated by the CPA to address consumer concerns. Now, there are certain features which, in my opinion, are very welcome additions in the Amendment Act of 2019. For instance, the enhancement of the state commissions, the numbers that would constitute the state commission from 2 to 4 reflects the commitment towards introducing more enhancement towards infrastructure, towards the constitution of benches, to ensure that there is adjudication, there is fast adjudication, and probably enable them to make decisions and conclude the complaints within the time contemplated by the Act itself. The introduction of product liability, inclusion of e-commerce as a platform, bringing within the fold of the Act the manufacturer, the producer, the service provider, the intermediary, anybody who has transacted on an e-platform also is a very welcome inclusion, and I do believe will give substantive power to the rights of the consumer to ensure its protection, to ensure the rights are protected and enforced. Probably will help to achieve the intent of the legislature a little bit more now. There is something to be said with regard to the healthcare sector. The healthcare sector originally was never included in the definition of service in the 1986 Act via the 2002 amendment. Very conspicuous by its absence is the word healthcare sector in the Amendment Act of 2019. Now, many would question as to why this bears any relevance in today's discussion, because originally healthcare was never included. It is by the judgment of the Indian Medical Association versus VP Shanta that the Honorable Supreme Court had read into the definition of service healthcare sector. Therefore, bringing into the fold of the consumer fora cases pertaining to medical negligence or with regard to the healthcare sector in its entirety. Interestingly, the bill that was placed before the parliament was supposed to be placed before the parliament in 2018, in fact, did mention the word healthcare to be included in the definition of services. Strangely, it is absent in the definition of services in the new Act. Whether it is the intention of the legislature to deliberately keep outside the purview of the Act, or whether the Supreme Court's inclusion of the healthcare sector would continue to prevail and it would still be read into the definition of services as it had been done before, is again something which would be tested in appropriate cases filed before the judicial fora. Now, let us for a moment discuss how this new Act can overlap in terms of jurisdiction with other acts. For instance, telecom services in its entirety have been included in the terms of, in the definition of the term service. If telecom service is to be included in terms of service and bringing all the telecom service providers within the jurisdiction of the Consumer Protection Act, there may be a very apparent and evident conflict between the Consumer Protection Act and the TRI-Act, between the TDSAT and the consumer fora as they stand. A question that begs an answer is, what would prevail? If for the same complaint, the complaint is filed in if for the same grievance, a complaint is filed in the consumer court and it is also filed in TDSAT. There are both proceedings go on and two different results come. Which is the decision which will be implemented? Which is the decision which would find favor? Which is the decision which would appeal? What if one decision is in favor of one party, the other decision is in the favor of the other? How is it that it would be implemented and how is it that it would be enforced? Further, we could consider the inclusion of unfair contracts. Now, unfair contracts is the very premise on which CCI as a jurisdictional authority stands. If the consumer forum is going to interpret a contract, rule on it to mean that the terms of that contract are unfair, and the same contract is interpreted by CCI, and it is ruled that the terms of that contract are not unfair, then again, we are presented with a situation where there may be conflicting orders with little light at the end of tunnel to figure out which is the one that will get implemented and which is the one which would not. You could also consider, apart from the CCI, the term housing construction has also been retained in the terms in the definition of services. Now, how this will be interpreted in view of the fact that RERA, a specialized act, is already in place, will again have to be seen. The fact that the Indian legal system essentially operates on the legal principle that special law will prevail over general law is something that has been tested and opined upon by different courts at different junctures with different conclusions. In MRMJF versus Aftab, it was held that Arbitration and Consumer Protection Act would apply simultaneously. Both those acts would continue to operate in tandem, and a consumer can invoke the jurisdiction of the Consumer Protection Act, all the while initiating arbitration against the opposite party as well. The fact that RERA can operate simultaneously and concurrent to Consumer Protection Act has already been held by Honorable Mr. Justice Nariman in the judgment of Pioneer Urban. Now, considering these jurisdictions, considering the obvious overlaps of jurisdiction, possible grounds of conflict, one does question as to why would we introduce a mechanism which would pose further conflict to jurisdictions, enhance the concept of parallel jurisdictions, which would add to the already pending legal cases. But this is an amendment which presents with it insertions which largely have been introduced with the intent of protecting the consumer, to ensure that the rights of the consumer are protected in every possible scenario. Again, a concept, how it is implemented, how it is received by the consumer community, how it is implemented by the legal community, how it is enforced by the judicial community, is something that remains to be seen. With this, before I conclude, I wish to thank Mr. Jitinder Singh Rana, the President, Mr. Ramanand Roy, the Vice President, Mr. KG Bansal, the Secretary, Mr. GS Pathak, Joint Secretary, Mr. Mithilesh Tiwari, the Treasurer, the office bearers, and all members of the Delhi Tax Bar Association for giving me this opportunity to speak with you all today. Mr. Roy?
मैडम कुछ क्वेश्चन आंसर है, मैं पढ़ दूं?
बिल्कुल, प्लीज जरूर.
फर्स्ट क्वेश्चन है, am I audible?
Yes, please.
Yeah, first question, whether it would actually be possible for the DC to deal with homogeneous litigation, bearing in mind the condition and functioning of the district commission at present.
What do you mean by homogeneous complaint?
This is the question by Ritu Raj.
Ji. What is the question?
Basically, his question is that it is possible that DC to deal with the complaint. I think the answer is no, because it's already district commission have power to deal the.
No, the complaint, I honestly do not understand the question, but if the answer to that question really would lie in whether it complies with the jurisdiction of the district forum. If it is a lease that is between parties, which the jurisdiction, pecuniary and territorial, is met, then it will lie to the district forum. As far as the product or service has been purchased or availed for consideration, it is under 1 crore, it would lie before the district forum.
Next, how the pendency can be reduced in state commission as well as national commission is their responsibility on the benches to pass orders within a reasonable time. The argument are advanced way back more than 1 year, but the benches are not making orders.
Well, this is more a grievance than
Yeah.
a question, actually.
Yeah.
So now this is something that we're all facing this. As members of this community, we're all facing this. It is something that unfortunately plagues our legal system. And I don't really blame the judicial benches for this. I don't blame the judges. I don't blame the lawyers, and I don't blame the clients. It is just our system is collapsing under numbers. I mean, a judge on an ordinary day in the National Commission or State Commission is hearing to 35 to 40 cases, right? Sometimes we lawyers take adjournments. Sometimes I'm not well, the other party is not well, the steno is not there. We all know there are infrastructural deficiencies as well. So, I mean, everyone is trying their best, but the fact that the orders are not being pronounced for a long time, unfortunately, I can't comment on that.
नेक्स्ट मैडम कुछ व्हाट्सएप में है, मैं उसको भी ले रहा हूँ.
जी जरूर.
हाँ, एजुकेशन पावर इज सेम एज पर द ओल्ड एक्ट और एनीथिंग न्यू इन द न्यू एक्ट.
Which power?
Education power.
Execution power is the same. Only penalties have been enhanced, which I've already discussed. Penalties have been increased from 3,000 to 25,000, from 10,000 to 1 lakh rupees.
Another question is, it is mandatory to adopt mediation because it is already inserted in the statute.
No, mediation can never be mandatory for the simple reason that the parties have to agree to mediate. As we all know that even when we are in court, a list gets referred to mediation, the consent of parties or the counsels present is always taken, because mediatory process in itself is something which is based on consent. So it is not something that can be mandated if consent is not present.
Next question is,
रामानंद जी, ये क्वेश्चन मेरा भी ले लेना बाद में.
आप बता दें, पहले आप बता दें सर प्लीज, बताएं.
If a person, मेरा एक क्वेश्चन है मैडम. If a person aggrieved from the judgment of the National Commission, he want to file the appeal in Supreme Court, he will go civil appeal or SLP, or what is the time limit or what is the fees?
What is the time limit and?
और फीस कितनी, इसकी जो है फीस कितनी है?
फीस कितनी है? Sir, ये if it's a final order, it will go up by way of a civil appeal, which is CA.
Okay.
It has to be filed within 90 days. You can file it. I'm actually, sorry, I may be a little confused, 30 or 90. And the fees is mandated under the rules, which will be given on the website, which can be, I believe by fees, you mean the deposit that has to be made.
So previous act में 5,000 थी मैडम, तो इसमें कोई amendment किया फीस का? I want to know that.
The rule, I don't think the rules have been amended to that extent, but I have to be candid to admit that I haven't seen it from that aspect, because it's rather procedural, but I don't think there is that amendment.
Okay, madam, thank you.
Suppose there is a specific mention in special law that no other law shall not be applicable. What would be the applicability of the common law?
Can you say that again, please?
There is a specific mention in special law that no other law shall not be applicable. What would be the applicability of the common law?
See, this is something that I already discussed in great detail. Now, Arbitration Act, IBC, all of these acts are special statutes. They operate in their own fields, and they in fact say that no other law will apply, no other act will, RERA will apply in the field of RERA, IBC will apply in the field of IBC, Arbitration Act will apply in the field of arbitration. We are well aware that Arbitration Act in fact excludes any civil from participating. But in the case of MR versus Aftab, in the case of Pioneer Urban, it is we are aware that the Honorable Supreme Court has held that Consumer Protection Act will always be in parallel with any of these special acts. all three acts have been tested and the Supreme Court has laid down the law to say they will apply in concurrence. आप consumer में भी जा सकते हो, आप IM में भी जा सकते हो, और आप दोनों में भी जा सकते हो. कोई they apply, both those acts apply.
प्रीतिका मैडम, कुछ हमारे जो अटेंडीज हैं वो उन्होंने हैंड रेज किया है, प्लीज उनको अनम्यूट कर दें. एक मिस्टर के आहूजा है, प्लीज अनम्यूट कर दें. आहूजा साहब, मिस्टर के आहूजा प्लीज. प्रीतिका जी, आपको मेरी आवाज आ रही है? रितिका जी, जब तक उनकी आवाज आती है, एक मिनट में उनको ये कर दूं. एक क्वेश्चन और है कि रिगार्डिंग समथिंग PIL के बारे में कुछ ये पूछ रहे हैं. पूरी इनके क्वेश्चन नहीं आ पा रहे चैट में. इन द न्यू एक्ट देयर वाज सम प्रोविजन लाइक PIL, प्लीज.
In the new act, there is provision like PIL.
Public interest litigation in the new consumer act. I think so. I think ये question here. Yeah.
I don't think so. I mean, a consumer can only file when he personally is aggrieved. I don't see if he can file under any provision a complaint which is largely in public interest.
रितिका जी, अगर आप मेरी आवाज अभी भी आ रही है तो प्लीज इसमें कुछ पार्टिसिपेंट जिन्होंने रेज हैंड किए उनको अनम्यूट कर दें. और मैं रिक्वेस्ट करूंगा अपने पार्टिसिपेंट से, अगर क्वेश्चन हो तो वो आप क्वेश्चन आंसर में प्लीज अगर टाइप कर दें. हाँ, यस, एक और क्वेश्चन है, कैन कंप्लेंट बी फाइल्ड ऑनलाइन आल्सो?
We haven't done it till now. I don't think there is a system for complaints online, but I am aware that in these forums, even a letter to the president in form of a complaint gets registered as a complaint. That can happen, but I don't know if an online complaint can be filed. But in the COVID times, of course, things have changed, and today an online complaint can also be filed and with a request for listing.
Yes. Yes. Whether the transaction of consumer nature have been included in the new act?
Whether the transaction of consumer nature.
I think इस क्वेश्चन के मतलब मैं यही समझ पा रहा हूँ, the whether the business or individual.
Whether business or individual?
हाँ, बिजनेस पर्पसेस हैं वो तो न्यू एक्ट में भी कवर नहीं हो गया, am I right?
नहीं. If you've used it for commercial purpose, for any other purpose apart from self-use, then it is ousted from the jurisdiction of the Consumer Protection Act.
Doctor and diagnostic center, any protection in this act?
See, again, this is something which will be a matter of interpretation. It was not included, healthcare sector was not included in the definition of services in the earlier act, which is the 1986 Amendment Act 2002. It was not included. But in the judgment of Indian Medical Association versus VP Shanta, by the Honorable Supreme Court read the health sector into the definition of services under the act, and after that all of these cases pertaining to medical negligence, the healthcare sector, came to be filed in the consumer fora. The fact that it found a mention in the 2018 bill but has not been included in the 2019 act, something remains to be said about that. I mean, the intention of the legislature will have to be tested to see if this has been deliberately left out. Then can it add into the definition? But again, will be tested in an appropriate case.
Madam, एक और है. What is the scope of section 19 in public interest under new act?
Sorry, the scope of section
19.
I'll just check that. Yes. So section 19 pertains to the power of central authority to refer matter for investigation or to the other regulator. Yes, so this is basically under the CCPA, where the court, if you will see under the section 10 of the new act, the CCPA has been established. So this is the authority for now. अगर आप ये सारे देखेंगे section 10 से लेके 27 तक, you will find that this new authority has a lot of power.
Yes.
Its power includes investigation. Its powers include, if it comes to a finding that there is violation, it can in fact implead itself. So the CCPA can implead itself into any litigation where between any two parties where they feel that consumer rights are being violated. So the CCPA also has an investigative wing. So under this section, the investigation can be ordered if it is opined whether if it is opined that there is any violation of consumer rights.
Next, what is the status of power of review?
Power of review has now been granted to all three forums.
On I think थैंक यू मैडम, मेरे ख्याल से सारे क्वेश्चन एक क्वेश्चन could it be concurrent power with the competition act, sorry?
Right now, yes, it seems like they have concurrent powers. Competition Commission also, I'm sorry. The Competition Commission also has powers to look into unfair contracts. Under the new act, the Consumer Protection Act also has the power to investigate into a list which pertains to unfair contracts. So then it would have to be assumed that at the moment it is concurrent power. Of course, it will have to be tested and decided whether it can be exercised concurrently or not.
That's all. Thank you, ma'am. Such a wonderful deliberation.
I am grateful that you gave me this opportunity.
I request our
very nice.
secretary to
very
please
much, madam.
convey a vote of thanks. Mr. KG Bansal, please.
Thank you, Mr. Vice President. Advocate Kankazi is a well-known personality and also a very good speaker. I would like to thank to her on behalf of all the members and members of Executive Committee of our bar for delivering a wonderful lecture on Consumer Protection Act 2019 amended. I would like to thank Mr. J.C. Gupta ji, the coordinator of today's webinar. I also want to thank all the members of our bar as well as members of various other bar for attending the webinar and making it a success. And lastly, thank to all the senior members for attending this webinar. Once again, thank you very much to Kankaji. Thank you very much.
It was my pleasure. Thank you very much.
Thank you, ma'am.
Thank you, ma'am. It was really
Thank
very
you.
nice deliberation. Thank you, ma'am.
Thank you very
Thank
much,
you,
madam.
Mr. Rana. Thank you, Mr. Roy.
Thank you, madam.
Please. Ritika ji,
Thank you.
Hello.
please आप close कर दें meeting. Thank you, everyone.
Thank you. Thank you.
very much.
Nice deliberation.
President Sahab, Secretary Sahab, thank you.
Please.
J.C. Gupta ji, namaskar.
Thank you, Ramji.
Thank you, sir. Thank you. आप
Ritika ji,
You are a
Ritika
great
जी, आप मेरी आवाज सुन रहे हैं तो
person.
please.
Arey
Thank you.
Ramanand. Hello.
Yes, sir.
Arey Ramanand. Hello.
आप बोलो, हाँ जी, रामानंद जी के लिए बोलो कुछ.
सर आगे क्या आप कंटिन्यू करें, आवाज आ रही है आपकी.
You are a wonderful man.
Thank you, sir. Thank you.
You have brought a very good speaker.
Yeah, thank you, sir.
हमारी
सर
knowledge
सारी
बहुत
चीजें हमारी रिकॉर्डिंग पे भी जा रही हैं.
हमारा ज्ञान बहुत बड़ा है. नया एक्ट आया, नई बातें बताई आपने.
नमस्कार जय श्री गुप्ता जी, नमस्कार.
आप प्लीज बंसल साहब अगर उनको आप कह दें कि ये क्लोज
जय
कर
श्री
दें.
गुप्ता जी, नमस्कार.
Hey, thank you.
Leave it कर जाएं सर, please leave it.
सर
अरे
सारे
भैया।
प्लीज लीव ले लें, प्लीज एग्जिट कर जाए।
Okay, thank you everyone.
थैंक यू सर, थैंक यू।
Thank you very much. So nice of you. Thank you.
Thank you. Thank you to all the members who attended the meeting. Thank you very much.
Thank you very much. Thank you
Sorry.
very much. So nice of you. All the very.
Welcome.